So good morning, everybody. No further excuses are accepted. I hope you slept well. Your nightmares were not too horrible, and you have enough stuff and material for your next sessions with your psychoanalyst.
Dreaming about validity cultures
and so forth, and what does it mean for your life?
That's right.
And where to put it, more into the superego or into the egosphere or the S, whatever the it. Who dares to ignore the effects of globality in the normative field? Albeit our understanding of what the global issue is in fact might differ a lot, but also how the legal orders of the world might react to it. Just to continue the procedure as every year, or to invent a new kind of legal normativity, Humanities law, as Ruti title named and presented her version very rigorously at our center a year ago. Is there something emerging of a global legal culture defined by a specific juristic style, argumentation, justification, patterns, symbolic references to what nature, mankind, namely humanity, procedural forms, and the heavy burden of all law to be efficiently applied? That is a body of enforcing the normative expectations of a global world. 4 speakers and an unfortunately absent chairperson, Matthias Herdegen. I tried to replace him, what is very difficult, because he had to give a leave I had to give him a leave for his participation in a commission of the Deutsche Bundestag, starting today, constitutional session, about the future tasks of military forces in Germany in a changing global world. So all these nice people have promised to give us deeper insights into the normative complex in a global world. Paul Schiff Berman, pleading for global legal pluralism in his fascinating book of the same name. Gunther Teubner.
Now available in paperback.
Okay. Gunther Teubner, so to say, an incurable systems theorist, and in the same time a practitioner of the law, and with a romantic relationship to fragments of the law and fragmentation in a global world. Marie-Claire Faublaise, as cosmopolitan jurist who knows and teaches her tribe, that is legal anthropologists, about the indispensable lessons that the presence of Islamic law teaches to the world. Last but not least, Youssef Denawi, scientific coordinator at our center, prodigal writer, an analyst of the Sinn und Macht in der globalen Moderne, trained in idealistic philosophy and Arab thought, sociologist by passion. We'll begin with Paul Schiff Berman, who took a ride from Washington to Bonn just for the sake of our conference. Thank you very much for that, for this kind of deep engagement in a scientific project. Very shortly, some hints at his work that you simply have to read. So where to start, at least? So everybody starts at Princeton University, and then afterwards it's New York University, and during law school serving as managing editor of the NYU Law Review, and so forth. But clerked for Chief Judge Harry T. Edwards of the United States Court of Appeals for the District of Columbia Circuit, and for Justice Ruth Bader Ginsburg of the Supreme Court of the United States. That's a rather solid basis, I would say. But then the academic positions came from visiting professor and visiting research scholar at Princeton University to Connecticut School of Law, then Dean at Arizona State University, finally George Washington University Law School Dean, and Robert Kramer Research Professor. And since 2013, Manatt, Professor of Law and Vice Provost for Online Education and Academic Innovation at the George Washington University. So this may be linked to his publications because cyberspace is something that is interesting for you from a legal point of view.
Yep.
And perhaps I mentioned this very important book, and this had was widespread all over the world, had a global really reception, one really can say. But something, I could continue with publications and so forth, but there is something you also must know. That he is also, and has been, and may still be attached to a sphere you would not have expected when you listen to this CV. He has been the professional theater director in New York City and artistic director of Spin Theater, a non-profit theater company, and so forth. So he's also linked to the sphere of the theater. So maybe the theater of global justice may be more close to him, and we'll wait for your performance.
I was a director, not an actor.
But you had good examples.
I don't know how good a performer I am. Thank you, Werner, for inviting me, and it's always a great pleasure to be able to come to Europe, where issues of legal pluralism are lived on a day-to-day basis and are much closer to the surface of people's thinking than in the United States. So let me talk a little bit about legal pluralism as both a descriptive enterprise and at least a little bit as a normative enterprise, although it has not historically been so. So legal pluralism, of course, focuses on the interaction of multiple normative systems. Sometimes those systems could be state-based and formal and official. Sometimes non-state-based, less official. We might have some dispute around the edges of what counts as a legal system and what doesn't. But in any event, what we're looking at is the interaction of systems. Not necessarily systems in Gunter's systems theory, but at least legal systems. And maybe some other cultural systems as well. Historically, this was a descriptive enterprise. Some political scholars who studied the relationship of church and state, for example, would use pluralism and look at the interaction of religious authorities and state authorities and really catalog the strategic interactions among the two. Anthropologists historically looked at the colonial indigenous interaction when colonial systems would come into an area and often would purport to install a new legal system based in the mother country. But what anthropologists noticed is that it rarely wiped out the indigenous systems altogether, and so we ended up with a layering of legal systems, and you see actors using one system strategically to gain leverage against another, and so forth. And so anthropologists would, again, describe the interaction of the systems. And we saw a little bit of this yesterday when we looked at Cameroonians in Germany and back in Cameroon and so forth. And we see the interaction of different normative systems, how it works, how it changes, how people's activities on the ground change the legal system and vice versa in a sort of infinite loop of feedback. So so that was kind of the state of play, and round about mid-1990s into the early 2000s, a group of scholars, of which I was one, started thinking about whether legal pluralism might be a useful way of looking at the international arena. So not just local settings, but the entire global legal system. Because, of course, we noticed that there were now anywhere between 100 and 150, depending on how you count, international and transnational tribunals, associations, arbitral bodies, and so forth that are all issuing decisions that are either binding or somewhat binding or normatively important in some way or another. And many non-state entities that have tremendous impact. So for instance, the entire global system of trade finance is governed by a gentleman's agreement that was formed in the back of a bar in Basel, Switzerland. And it governs the rules of trade finance whether an individual country wants to be part of it or not. If you want to be part of the international banking system, you're part of it. So we thought that it might be a useful rubric for studying the international arena as a way of looking at these interactions. And among other things, legal pluralism was particularly useful, I think, in the United States because it got us out of endless debates which are still going on in the United States about whether international law counts as law or not. And the advantage with legal pluralism is we can sidestep that debate and say it doesn't matter whether you want to call it law or not. If people on the ground indicate the impact of it, then it's having an impact, period. So we talked yesterday in some of the discussions, we talked about changes in legal consciousness over time. What it is that gets into people's heads, whether they are state actors or whether they're just people in their daily lives. What do you think of as what is normal? What categories do you use? When you are meeting to discuss a policy in government, does someone in the room mention human rights, for example? If they mention human rights, you're using a framework that didn't exist prior to, let's say, 1900 or 1945 or something, which is now part of the decision-making process. If that's happening, then international law is having an impact, whether you want to call it law or not. If people in their daily lives think in terms of certain categories that are legally based, then that's having an impact. So legal pluralism has been useful, I think, descriptively, and I think we've largely been successful at having legal pluralism be accepted as a rubric. In fact, I was intrigued. A number of people who've reviewed my book, they say, well, he makes both a descriptive and a normative argument. The descriptive argument is completely uncontroversial, so I won't spend any time on that. And I consider that a huge victory because 15 years ago, 20 years ago, it was wildly controversial. So I think that in and of itself is an advance. But the question is, or the next question then is, could there be a normative project underlying legal pluralism? Could we use legal pluralism as a way of understanding, of not just understanding, but of prescribing certain sorts of legal arrangements, doctrines, procedures, and so forth? I'm not sure, but I have been pursuing a possibility of how we might think of it. And it's grounded in how do we manage the hybridity that exists all the time. So if we accept that there are these multiple normative systems that are layered on top of one another, or that where there's an authority in one place, but it's only ever a partial authority because there's other entities over here that are saying things that have an impact. And if we accept that, then the question is there a way of managing that that we might think of as normatively desirable? So how do we encounter a stranger generally? If there's someone whose norms are different from you, they dress differently, they speak different languages, whatever it might be, you could, if you had a disagreement, decide that your particular rules win. My rules win. It's what I call sovereigntist territorialism. If we can determine where something is, located in physical space, figure out where the borders are, and then say, this law wins, this law is irrelevant, maybe that's a way of solving the problem. And in some situations, that's fine. If I go out here and I get run over by a car, and I want to sue or prosecute or something like that, the idea that German law might apply to that driver is not wildly controversial. Although as soon as I start getting into some defect with the car and where the part was made and so forth, we'll start getting much more complicated. But in some situations, a territorial location and using sovereignty to choose a law is okay. But in many situations, that won't work. Werner mentioned the internet is an obvious example, but many times, and maybe the part in the car is also an example, many times it will be very difficult to locate something in physical space. And you end up with debates that are not easily solved by just choosing a law arbitrarily. So one example that I have used now for 15 years, because it's such a good example, is a case involving Yahoo, the internet service provider, and people who were uploading onto Yahoo's servers in the United States Holocaust denial and Nazi memorabilia material, legal in the United States, not legal in France, where it was downloaded. And the idea that the French authorities could go after Yahoo.fr, which is the French subsidiary, that wasn't controversial. The question is, could they also go after Yahoo.com, the American parent company? And that's a complicated question, but one thing I am sure of is that it should not be resolved as it was based on the physical location of the stock certificate whereby Yahoo.com owned Yahoo.fr. It happened to be in a safety deposit box in France, therefore the French court said it had jurisdiction. That strikes me as a peculiar way of deciding it, but it's what happens when you base everything on physical territory. You have to locate something that you can grab in a physical territory and then create the rule. That strikes me as not only arbitrary, but often incoherent. All right, so that's one option. You could also go the other option, and Werner mentioned Ruti Teitel's humanities law, or some sort of global international law that governs everyone. That's what I would call a universalistic answer. And if you're encountering a stranger, that means basically we're all the same. We may look different, we may wear different clothes, we may speak different languages, but at root level, we're all the same. And again, sometimes that's useful. There may be certain ways in which, as human beings, we want to say there is a humanities law with regard to certain norms. And even with regard to things like commercial transactions, you can sometimes get treaties or some sort of uniform law that could govern. And so again, that's fine in some situations, but again, I would say that it's only ever going to be partial. There are many ways in which we are all different and should be different, and cultures are different, and people's particular commitments, emotional commitments, may be local or may be community-based, may be epistemic, but nevertheless different from person to person or place to place or community to community. And that's good. There's nothing wrong with that kind of diversity. And so I think that you will never have one universal law that will apply to everyone, and as soon as you try to create it, it will get subverted on the ground in individual situations. So what's the alternative? Because sovereigntist territorialism and universalism are both fundamentally jurispathic, to use a term that Robert Cover, American legal philosopher, came up with. Jurispathic means it kills off certain legal interpretations. So you choose this law and not that law to deem legitimate to a particular dispute. And it may be my law versus yours, or it may be this universal norm rather than your particular norm, but both of them are fundamentally jurispathic. Could you instead come up with a jurisgenerative way of analyzing a situation of hybridity? One that tries as hard as possible not to kill off the multiple legal and quasi-legal norms, but actually takes them seriously and tries to develop more of a hybrid solution, or what Hannah Arendt referred to as a mental capacity appropriate for an active relationship with that which is different. A mental capacity appropriate for an active relationship with that which is different. Could you, in other words, figure out a way to try to foster in the decision maker, whoever the decision maker is, a habit of mind that fosters interaction, adaptation, accommodation, as opposed to choosing one over the other? So, I set out to look for in the world and to advocate for what I would call pluralist mechanisms, procedural rules or institutional designs or discursive practices that will tend to do that will tend to build into the decision maker these sorts of habits of mind. So let me give you some examples that actually exist in the world so that you don't think this is too abstract. Here's an obvious one that comes from the European context. The European Court of Human Rights has, as you probably all know, a margin of appreciation doctrine. Very controversial. Not everyone likes it. I'm sure not everyone agrees with how it's applied in any given situation. But think of it as a pluralist mechanism, right? So some people wanted a universalist solution. Let's push for greater human rights, more humanities law, and let's make the European Court of Human Rights the arbiter of that and bring these recalcitrant nation states into line by pushing towards ever greater universal norms. That was one side of the debate. Another side of the debate was, we don't want a European Court of Human Rights at all. We want nation states to predominate, and constitutional courts are good enough. And so both sides, in a sense, get half of what they wanted. So you might think of it as sort of a half a loaf solution. Well, you know, half a loaf is better than none. I think from a pluralist point of view, you might see it as a loaf and a half solution. Better than if either a fully hierarchical European court existed or no European court existed. Because what you get is a constant state of interaction and dialogue where both entities have to pay attention to the other, and there is some wiggle room for a recursive process of dialogue and voice. Another example, subsidiarity doctrine, another European example, also comes from the Catholic Church, tends to focus on whether you can push things down to the lowest level of government that's appropriate to solve a problem. I'm actually not so interested in subsidiarity as a question of whether it should be more local or not. But what I am interested in is a decision maker always thinking of whether there's some other decision maker that might be more appropriate. Because that habit of mind, again, fosters in the decision maker an outward-looking approach. So you have a problem that's presented to you and you think, should I be the one solving this problem alone? Or are there other courts or tribunals or decision makers or arbitral panels or associations, either official or not official, that might be better situated to address this problem, or maybe we should jointly be addressing this problem? Mixed tribunals would be another example of a hybrid solution. So in post-conflict justice, there has been a move to use international courts with regard to, let's say, Yugoslavia, the former Yugoslavia. But there's also criticism of international courts because they're too distant from the local setting. On the other hand, domestic courts within the post-conflict setting often are either non-functional or they're captured by one ethnic group over another, and so they also might be seen to be illegitimate. So what about a mixed tribunal or hybrid court, where you have members of the international community as well as members of different local groups? Arguably, they haven't worked perfectly, but arguably they gain more legitimacy among more different people because they bring more voices to the table. Similarly, you could imagine in a mixed ethnic or mixed religious setting, making sure you have some seats on a tribunal or on a governmental panel or on a council that are set aside for different sorts of groups so that you are sure you have a mixed set of voices at the table. And there's actually been some interesting research on juries in the United States, and they've suggested that if you have a more heterogeneous group, you not only end up with people paying attention to more different kinds of perspectives, but you actually end up with more accurate results. More perspectives actually lead to better solutions. And in the jurisdictional arena, we could pay less attention to wiping out jurisdictional overlap and instead see jurisdictional overlap as a good hybrid mechanism for allowing for dialogue. So it's interesting that the word jurisdiction comes from juris dicere, which means to speak the law. Doesn't necessarily mean to enforce the law. And so having multiple entities speak to a legal problem may actually be useful even when they can't enforce it, and you end up with a dialogue. So let's just take another example of jurisdictional overlap. Very famous. Juan Garzón, a judge in Spain, asserts jurisdiction over Augusto Pinochet, former Chilean leader, leads to a 2-year international discussion of head of state immunity, but perhaps even more importantly, it galvanizes human rights activity within Chile itself so that other members of Pinochet's group were prosecuted. It gave leverage. Even though Garzón's assertion of jurisdiction was never literally successful in the sense that Pinochet never got extradited to Spain to stand trial in Spain. So sometimes just the existence of some other jurisdiction that speaks the law can have an impact elsewhere. Another international example, we talked yesterday a little bit about the CEDAW Convention on the elimination of all forms of discrimination against women. So CEDAW had an impact in Hong Kong, for example, because women in Hong Kong were trying to get the ability to inherit property for years, unsuccessfully. Regardless of whether CEDAW literally applied in Hong Kong, by making an argument framed in terms of CEDAW, the women were able to petition their own legislature better than they would have without CEDAW. So that's another example of jurisdictional overlap. In the United States, it's lived all the time in federalism. Any federalist country has a constant interaction and overlap, and we have long talked about the existence of 51 sovereignties in the United States as being a laboratory for democracy, a laboratory for different experiments to take place. So we could think of the encounter with other systems as a positive and not just something we have to put up with. So the keys are: don't wipe out pluralism, maintain the jurisdictional overlap, consider community affiliations and multiple community affiliations, try to defer, try to think of systemic values of whether, in this particular case, you can accommodate the multiple norms. There will be some times you can't accommodate the multiple norms. There will be some times where some norm that is asserted by someone is so outside the realm of what you as a decision maker feel is legitimate or appropriate that you can't defer to it. Maybe it's some religious law that's so illiberal that a liberal community can't countenance it. Or maybe it's I'm asked to recognize and enforce the judgment of some state, whether it's North Korea or something, that I just don't think has a fair enough procedure that I'm willing to recognize that judgment. Whatever it might be, there will always be some times where there's something that's so beyond the pale that I will not be able to enforce it. But if that's the case, a more pluralist approach would require you to explain why you're not enforcing it, and to put on the table not just, well, it's my law so it wins, but what is the core commitment, whether it's a human rights commitment or some commitment of your community that is so fundamental that as a matter of public policy you can't pay attention to this other norm. In other words, if you're going to be jurispathic, if you're going to kill off or say that you're not going to pay attention to this other normative commitment, at least say why and justify why and put something on the table in counterbalance to it. And design your institutions or your procedural rules with an eye towards dialectical interaction. Whether it's a mixed tribunal or some sort of a way of creating feedback loops among multiple voices, communities, and decision makers. Now, that's not going to solve all conflicts. This is not a world of sweetness and light that suddenly comes about and now everybody's happy. First of all, some people won't even play the game. So if you want to create, let's say, a mixed tribunal where lots of people come to the table and have a voice, there might be some people who say, I refuse to be part of your table. Maybe they don't want to be there because there's a woman on the other side of the table and they refuse to talk to a woman. Maybe there's hatred that goes back hundreds and hundreds and hundreds of years and they can't be in the same room together, as happened, let's say, with trying to negotiate a truce in Syria, right? Just getting the parties into a room together proves to be difficult. Or maybe there are people who are so committed to terrorism or violence that they're not interested in having a dialogue or in trying to tame that violence. So obviously, this won't solve all problems, and there will always be wars, and there will always be lawbreakers, and so forth. But could you tame conflict in some settings? Or, as the philosopher Chantal Mouffe put it, could you turn enemies into adversaries? So if you think, let's say in the US context, there's a big debate about abortion rights. So if there are two sides and they're having a debate in the US Supreme Court about the scope of abortion rights, they are adversaries. If they're out bombing abortion clinics, then they're enemies and there's not much you can do. But if you can turn more and more of those people who are bombing the abortion clinics and bring them into a dialogue where they can actually argue about their positions in some other forum that is not using violence, that strikes me as an advance. And the more times you can do that, the better. And it is possible, anyway, that pluralist mechanisms will be better at taming those conflicts, providing voice, at least in some circumstances. And it may be that in a multivariate world of pluralism, that is the best we can do. Thank you.